Before modern privacy laws, personal data was a limitless, unregulated resource. Companies aggressively harvested digital footprints and personal details with zero oversight. This lack of regulation gave rise to deceptive practices, like sugging, where marketers would approach individuals under the guise of conducting legitimate market research, only to use their answers to push aggressive sales pitches. Consumers had almost no legal recourse. Their information was extracted and sold without their knowledge, treating individuals merely as targets rather than the rightful owners of their own personal details. These deceptive tactics eventually generated thousands of complaints, forcing regulators to realize that the industry could no longer self-police. Curbing this exploitation would require a structural legal intervention severe enough to force global businesses to pay attention. In May 2018, the European Union provided that intervention. They enacted the General Data Protection Regulation, commonly known as GDPR. The legislation codified a strict new rule. Personally identifiable information, your name, your location, your unique characteristics, is a valuable asset that legally belongs to you, not the corporation collecting it. To enforce this, the EU established a severe baseline penalty. Mishandling data risks fines up to 10 million euros, or 2% of global revenue. For flagrant breaches, the penalty doubles to 20 million euros, or 4% of revenue, creating an existential risk. Because these penalties apply to any company surveying European citizens, regardless of where the business is headquartered, GDPR immediately became a global standard for corporate survival. To avoid financial ruin under these new laws, organizations have to map out a heavily regulated chain of accountability for every piece of information they touch. At the very base of this structure is the data subject, the specific human being whose privacy the law is designed to protect. At the top is the data controller, usually the client commissioning the research. They dictate why data is collected and how it's utilized. Because they set the rules, the controller carries ultimate legal liability. If a breach occurs, regulators look directly at them. Under GDPR, a business cannot outsource a survey to a third party and wash their hands of the consequences. The top-level decision-makers hold the risk. The actual execution of the research, the interviewing, the coding, the transcribing, is handled by a subcontractor known as the data processor. The processor is legally bound by the controller's documented instructions. They have zero authority to deviate from the plan or use the collected information for their own benefit. To keep both of these parties in line, organizations handling large volumes of data are required to appoint a data protection officer, or DPO. The DPO operates as an internal watchdog. They are the ultimate authority on compliance, actively monitoring the organization's processes and advising staff on legal obligations. The inherent friction between the controller directing the data flow, the processor executing the tasks, and the DPO monitoring the legal boundaries creates a self-policing loop that actively defends the data subject's rights. By enforcing this strict liability, the law pushed market research away from raw data extraction and toward a practice of ethical stewardship. Organizations must now operate with absolute transparency. Before a survey begins, researchers are legally obligated to explain the specific, lawful basis for their study to the individual being interviewed. Researchers must also secure clear, explicit consent before extracting any personal information. This strict requirement eliminates deceptive tactics like sugging by forcing organizations to state their true intentions up front. Mandating consent and ensuring transparency shifts the power dynamic back to the consumer. The data subject can choose to participate, making the research a willing partnership. To safely operate within these tight regulations, the industry relies heavily on two specific data handling practices, anonymization and pseudonymization. This involves intentionally severing personally identifiable information from survey responses. Answers are kept for analysis, but the name and face are replaced with a scrambled ID number. Separating these identifying details limits the organization's regulatory liability, while ensuring the participants' privacy remains intact. The potential for massive fines acts as a significant deterrent. But by forcing transparency and demanding that companies treat personal information with respect, the law successfully rebuilds the vital trust between researchers and the public they study.